Hello everyone, welcome to second part of the important articles. In the earlier video, we have discussed Article 21 as well as Article 13. In this video, we will cover more articles. Okay, let us start. Article 26. The Article 26 deals with the right to manage its own religious affairs. This gives the right to the religious denominations to manage their own religious affairs. It gives the right to establish and maintain religious institutions. It gives the right to manage their own religious affairs. It gives the right to acquire property and also maintain those properties, also administer those property according to the law. But there is a reasonable restrictions which can be imposed by the parliament. As it says, administer according to the law. This law subjected to public order, morality as well as health. But why we are discussing Article 26? Recently, the parliament has enacted Waqf Amendment Act of 2025. This affects two articles. One, Article 25, Article 26. Article 25 majorly deals with the right to religion of individuals. Means the individual has a right to conscience, right to profess, right to propagate their religion. But Article 26 deals with the right of groups of people or the rights of religious denominations. The Waqf Amendment Act, which enacted by the Parliament, affects Article 26. In Shirurmat case, Supreme Court had said that right to manage the religious affairs, which provided under Article 26 Clause B is a fundamental right. No legislature can take away Article 26B, which gives the religious denominations to manage their own religious affairs. Supreme Court in Shirurmat case said that the clauses under Article 26 C and D can be taken away. Parliament can be interfered in these matters where religious denominations can acquire property and administer according to the law. According to law, that means the parliament can enact a law and may these clauses are subjected to that particular law. For example, the parliament or state legislatures enacts any particular law which manages Hindu denominations or temples properties. Like that, the Waqf Amendment Act has been enacted by the parliament under Article 26C and D, which deals with the right to acquire property and administer according to the law, subjected to public order, morality as well as health. Okay, this is Article 26 with respect to Waqf Amendment Act of 2025. Okay, next article is Article 44, which deals with Uniform Civil Code. Uniform Civil Code deals with the uniformity in personal laws. Uniformity in personal laws. What are the personal laws? These personal laws which deals with succession, which deals with inheritance, or which deals with divorce. These are called personal laws. In India, we have different personal laws for Hindus, Muslims, right? Article 44, state can enact a uniform civil code in the country, which can ensure there is uniformity in personal laws with respect to succession, inheritance and divorce. In Shabono case, Supreme Court urged the parliament to enact a uniform civil code. And also Sarla Mudgal case, in this particular case also Supreme Court urged the government to enact a uniform civil code. Since the Article 44 included in directive principles of the state policy, which is not enforceable in the court of law, the Supreme Court's recommendations or requests with respect to Uniform Civil Code are not binding on the government. Even any individual can't be go to the court to enforcement of the Article 44 because it's not enforceable because it is included under directive principle of state policy. This is Article 44. You can refer Sarla Mudgal case as well as Shabano case. In these two cases, Supreme Court had said that urged the central government to enact a uniform civil code in the country. Okay, and next is Article 72 and Article 161. Article 72 and 161 deals with pardoning power of the president and governor. Why we are discussing Article 72 and 161? Because recently Trump, after becoming president, pardoned various criminal acts in the United States. This was very much in news. Because of this, we will discuss some of the very important articles which are mentioned in the Constitution, which gives the power, both president as well as governor, the power to pardon. Under Article 72, president has the power to pardon, to remit, to suspend, respite any of the sentences. Under Article 161, governor has the power to pardon or suspend, remit, or any of the powers covered under Article 72. But only difference between the president and governor is that president has the power to pardon the punishments of court-martial, also the union laws, the court-martial, the federal offences, and also death sentences as well. But with respect to governor, of the pardoning power of the governor only deals with the state laws. And the governor is not entitled to pardon a death sentence. This death sentence means pardoning death sentences is only dealt with the pardoning power of the president under Article 72. But with respect to, is the pardoning power is discretionary of the governor or the president? In Kehar Singh case, Supreme Court had said that individuals who appeals for the pardoning power, who appeals for the pardoning of their crimes, they don't have a right to oral hearing. And also, if these power exercised by the president and governor are arbitrary in nature, these are subjected to judicial review. And also, in Perarivalan case, Supreme Court had said that the cabinet, means the Council of Ministers advice with respect to Article 72 and 161 is binding on the president and as well as governor as well. Means the governor should act on the advice of the Council of Ministers. With respect to Article 72 and 161, nominal executive doesn't have a discretionary power. This is Article 72 and 161. Okay, thank you.